Welcome you all in Citizen Justice Forum Legal, Financial and Social Awareness video series. Today's topic is about Maharera, how builders dodge the order of RERA. Suppose if you have got an order of refund or you have got an order of paying interest, the builder keeps quiet, he doesn't go for an appeal as per section 43 subsection 5 of Maharera, where he has to pay the dictatorial amount. Suppose my refund is for 5 crore rupees and his appeal has to be heard. So he initially it was from 30% to 100%, whatever the amount decides by the presiding officer of the Maharera Appellate Tribunal. But nowadays they prefer that 100% amount is deposited by the builder if their appeal is to be heard. So to save from depositing that amount, they go via the other route. They prefer a miscellaneous application, a review application of the order, where they don't have to pay even 1,000 or 5,000 rupees, which normally he has to pay for the complaint. Now in one of the order, which was publicized in the newspaper, that this was the highest amount. The home buyer was paying the amount from 2010 and he paid around somewhere 5 crore 7 lakhs, and if you calculate the interest at the rate of 10.4%, so he was getting more than double the amount, more than 10 crores as a refund. The builder kept quiet. After 523 days, he files a review application, and which was extensively argued by Advocate Sharon and Advocate Lakshmi, and the review application after 1 year, it was got rejected. Now we will go into step by step how the things are happening in Maharera. Now, why don't builders file an appeal? Instead, they prefer a review petition. I already explained you. We'll go into the second slide. Maharera orders the highest amount of refund to an individual home buyer for rupees 5 crore 17 lakhs 7,805 with an interest of 10.4% per annum from the time of money paid to the bidder, that is from 21st August 2010. It's almost 12 years, my friend. The building is still not complete. 29th March 2019, the first order, into brackets, that complainant wants to withdraw from the project and is seeking refund. The possession date is far away, that is 31st December 2016, which was extended to 31st December 2023. And he is a super senior citizen at the age of 85. He doesn't want to that long. He requested the Maharera, which was also argued by Advocate Lakshmi and Sharon, that we want the refund back, and the Maharera adjudicating officer Mahadev Kulkarni, in order passed on September 18, 2020, allowed the aggrieved home buyer to withdraw from the project. Review application was filed after the delay of 523 days of first order as well as challenging the second order. The promoters ought to show their bona fides by depositing the amount as contemplated. So, in an important judgment delivered Thursday, 11 November 2021, just 1 year back, the Supreme Court held that the condition of the pre-deposit imposed on the promoters for filing appeals under Section 43 subsection 5 of the Real Estate Regulation and Development Act 2016 is neither discriminative nor violative of Articles 14 or 19 subsection 1G of the Constitution of India. सादी और सरल भाषा में अगर मैं ये जो हमारा संविधान है उसकी अगर मैं बात करता हूं, तो अधिनियम न तो भेदभावपूर्ण है और न ही अनुच्छेद 14 और 19 1 और जी का उल्लंघन करता है, यानी ना वो भेदभाव रखता है ना उल्लंघन करता है. The legislature in its wisdom intended to ensure that the money once determined by the authority be saved if appeal is to be preferred at the instance of the promoter after due compliance of pre-deposit. The bench headed by Justice U. Lalit observed, the court noted that the promoters ought to show their bona fides by depositing the amount so contemplated. The case which I am quoting is New Tech Promoters and Developers Private Limited versus State of UP. The rule 36, that when you can file a review application, it is also very clear, but the builders are very smart, they engage very smart advocates, and they, play with the rules and regulation. So, just to frustrate the home buyer. So what does the rule 36 of Maharera says? Review of decisions, directions and orders. Rule 36A, any person aggrieved, whether it can be a home buyer also and it can be a builder also, by direction, decision or order of the authority, adjudicating officer, from which no appeal has been preferred. Means there is no scope that you can go for an appeal. There is no provision for an appeal. From which no appeal is allowed. May, upon the discovery of new important matter or facts or evidence which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time of the direction or at the time of the hearing, decision or order was passed on the account of some mistake or error apparent from the face of the record, or for any other sufficient reasons, may appeal for a review of such order within 45 days. This is very important. Of the date of the direction, decision or order, as the case may be, to the authority or adjudicating officer. An application for such review shall be filed in the same manner as a complaint under regulations. The authority or adjudicating officer shall, for the purpose of any proceedings for review of decisions, directions and orders, be vested with the same powers as vested in civil code under the Code of Civil Procedure. This you may read the slide. I don't want to waste much of the time in reading the slide, but it is available. We'll come to what the Honorable High Court, when the judgment was quoted, right, about this review application. I am reading the clause number 8 of the order which was passed by the RERA authority. The Honorable High Court has also observed, while deciding the matter in the writ petition number 2737 of 2017, Nilkamal Realtors Suburban Private Limited and others, that the interest payable under section 18 is a compensation. Considering the above laid down by the Honorable High Court of Bombay, issuance of recovery certificate based on the order of the adjudicating officer under section 40 subsection 1 read with rule 3 was held to be valid. It is apparent that as per the law laid down by the Honorable High Court, the order of the adjudicating officer for refund of amount of consideration and interest was held to be the compensation in the form of a compensation towards the amount invested by a allottee. In the light of these facts, the practice followed by the Maharera to refer the complaints for the refund, consideration and interest, so also for compensation, has been approved by the above referred decision of the Honorable High Court. So in the Nilkamal case, the High Court has kept that provision that the refund of the home buyer's amount has to be heard by the adjudicating officer. It is never denied by the High Court of the Bombay in the Nilkamal matter case. 9th point of that order, considering the above decision, issuance of a recovery certificate based on the order of adjudicating officer under section 40 subsection 1 read with rule 3 was held to be valid. It is an apparent that as per the law laid down by the Honorable High Court, the order of the adjudicating officer for refund of amount of consideration and the interest was held to be the compensation or in the form of compensation towards the amount invested by the allottee. In an earlier decisions of the Honorable High Court dated 6/12/2017 and 2018, referred to the above same view is taken and the refund of the paid consideration as well as the interest thereon have been treated as a compensation. It is apparent that the practice followed by the Maharera for referring the complaints as stated above for refund of consideration and interest thereon can be viewed as the complaints for compensation, and the adjudication was also within the jurisdiction of the adjudicating officer as per the lay laid down by the High Court. Now, 10 of that order Point 10 of that order. A reference is also made to the decision of the appellate authority Maharera decided in Pankaj Kishore Agarwal versus Real Gem Buildtech Private Limited dated 31st August 2020. Other such decisions by the decision, the appellate authority has expressed its view particularly as to the jurisdiction to the authority and the educating officer. This decision is subsequent to the above said decision of the Honorable High Court. The decision of the Honorable High Court has not been considered or referred. The question as to the jurisdiction of the authority and the educating officer was under consideration of the Honorable Supreme Court, wherein almost all the relevant provisions of the Act have been considered. One of the questions framed by the Honorable Supreme Court is question number 2, that is, whether the authority has the jurisdiction to direct the refund of the amount to the allotee under section 12, 14, 18 and 19 of the Act, or the jurisdiction exclusively lies with the adjudicating officer under section 71 of the Act. All the relevant provisions have been considered at length and following is law laid down. So let us see what has been laid down. From the scheme of the Act, of which a detailed reference has been made, and taking note of power of adjudication delineated within the regularity of the authority and adjudicating officer, what finally culls out is that although the Act indicates the distinct expression like refund, interest, penalty and compensation, a conjoined reading of section 18 and 19 clearly manifests that when it comes to refund of the amount and interest on the refund amount or directing payment of interest or delayed delivery of possession or penalty and interest thereon, it is the regulatory authority which has power to examine and determine the outcome of the complaint. At the same time, when it comes to a question of seeking the relief of adjoined compensation and interest thereon under section 12, 14, 18 and 19, the adjudicating officer exclusively has the power to determine, keeping in view the collective reading of section 71 read with section 72 of the Act, if the adjudication under section 12, 14, 18 and 19 other than compensation are analysis, if extended to the adjudicating officer, are praised that in our view may intend to the expand and embed the scope of the powers and functions of the adjudicating officer under section 71, and that would be against the mandate of the Act of 2016. Now further in the order, point number 12. As such, today a law stands as per the decision of the Honorable Supreme Court dated 11/11/2021, 1 year back. It is clear that adjudicating officer cannot consider the prayer of the allotee for refund of consideration and interest, and the jurisdiction of the adjudicating officer is limited to the jurisdiction of the compensation only. This aspect of the matter is made clear by the judgment dated 11/11/2021. However, the law laid down by the Honorable High Court was enforceable till date. Here, the authority is very clear that till 11/11/21, the order of the High Court was enforceable till date. The jurisdiction exercised by the interpretation of the law by the Honorable High Court dated 6/8/2017 and 2018 and 9 March 2020 cannot be said to be without jurisdiction. More so, as the Honorable High Court has classified the refund of paid consideration as well as the interest thereon as a compensation. Now, because the law laid down by the Honorable Supreme Court, the adjudicating officer cannot entertain or consider the complaints as to refund of the consideration and interest, so also the interest payable for delayed possession, after laid down by the Honorable Supreme Court in the above referred decision dated 11/11/2021. Also, the adjudicating officer cannot entertain or consider such complaints which are pending and required to be decided after the date of the judgment of the Honorable Supreme Court 11/11/2021. Hence, the review application is liable to be rejected. The review application stands rejected, no order as cost. So now friends, now what I want to convey here is, when you have an order and if bidder goes to for a review application rather than appeal, the first thing is you have to approach the High Court, file a writ petition that the bidder has no right of the review. If he wants, he can challenge that order in the appeal by paying the dictatorial amount. If it is 1 crore, he has to pay that 1 crore rupees, and then only his appeal has to be heard. Now, before 11/20/21, whatever the order has been passed by the adjudicating officer holds good till 11/11/2021. Only after the Supreme Court judgment, you cannot have, the adjudicating officer cannot have the power to pass an order of refund. Now, if you all like this video series, I would like you to thank you for watching this video, and if you are happy with the content, you can share with your friends, with your contacts, and click the subscribe button. And if you want to have any topics to be discussed, please put it on the comment box so that next time we can take that topic. And see you then by next time in the video. Till then, stay safe, stay fit. See you all.